then. Hello everyone, and welcome to this information session on research data protection impact assessment. My name is Sean Lacey. I'm the Research Integrity Officer, Research Integrity and Compliance Officer in the university. And I'm delighted here to be joined by Carmel Hayes, who's our Data Protection Officer, that's going to guide us through data protection impact assessment and the screening checklist that we have associated with it as well. Now, my role is I'm just going to give a small bit of background information to this, and then really just hand over to Carmel, who's going to lead out in this session. Just to kind of give it a small bit of context to why we're actually having this session or how did it all come about. So in March 21, we had data protection policy was published. And in our data protection policy, it states that data protection impact assessments are required under general data protection regulation under certain circumstances. These circumstances including when the processing of personal data may result in a high risk to the rights and freedoms of a data subject, where there is processing of large amounts of personal data, where there is processing of special categories of personal data, and where there is automatic processing or profiling. Now, this has been the case back in March 21 across the university. As some people in the room may be aware that towards the end of 22, in November 22, the Human Research Ethics Committee was formally established in the university. And what we tried to do then from the start of 2024 is, as part of the application process, so when researchers started submitting applications or would submit an application to the Human Research Ethics Committee, we were encouraging them to complete a data protection and impact assessment screening checklist. And if they ticked yes to any of those options that were in this checklist, that they would then, we'd signpost them then towards the data protection impact assessment that they would need to do as per the data protection policy that we had in place in March 21. So I suppose for most of the calendar year of 2024, in the Human Research Ethics Committee, we were signposting or encouraging researchers to, I suppose, complete a data protection impact assessment screening checklist at the very least as part of the application process, but it wasn't required until December 24. So in December 24, as approved by the Research and Innovation Committee in the university and the Academic Council, it is now part of the human research ethics process that when a researcher submits an application to the Human Research Ethics Committee, they need to complete the research ethics screening checklist, research data protection impact assessment screening checklist at a minimum. And if they tick yes to any of those options, then they actually need to pause. They can't submit the application to the HREC as in their human research ethics application to the HREC. They first need to complete a data protection impact assessment. And that has to be done before an application can be processed through the Human Research Ethics Committee. And when it comes to actually submitting your application to the Human Research Ethics Committee, it's now policy that as part of the application pack, at the very least, there's the screening checklist document included. And if there's yes to any of the options in that checklist, that it's also accompanied then by a data protection impact assessment. And it has been assessed by our data protection officer, Carmel Hayes. I've mentioned data, it's obviously a mouthful saying it, but I'll say it again in the long term. I've mentioned a data protection impact assessment screening checklist a few times. We have a document on our Human Research Ethics webpage, which actually gives access to the checklist. And this is taken from our data protection impact assessment. So we've extracted this from the data protection impact assessment form. Sinead will pop in 2 links there into the chat just for your own information. One being our Human Research Ethics webpage, so the link to that, and then also the link to the screening checklist as well. And you can see as part of the screening checklist, there's 10 items to be looked at. Now, these evolved from 9 to 10 in recent times, and this checklist is not just something that is kind of, I suppose, driven by MTU. This is actually seen nationally, and you can see that there's a link there to the Data Protection Commission as well in terms of this checklist. Now, really at that point then is to hand over to Carmel, who's actually going to talk us through the checklist. What does this checklist mean in broad terms in research, along with, look, what's the bit of background information to how do we get to this point? And also, when it comes to actually completing a data protection impact assessment, what's involved. So I'll hand over to Carmel there. And as Carmel is just setting up and getting the sharing the screen, we do welcome questions. And we will have time at the end to take these questions, take the questions. So maybe throughout the session, if questions come to mind, if you want to pop them into the chat, we will facilitate them then later on. Okay. Thanks very much. And that's there, Carmel. You're good to go. Thank you very much, Carmel.
Great stuff. So listen, delighted to be here. Hopefully we'll provide you with some useful information or at least start conversations. And if you have any questions, either during the presentation or afterwards, or if you want to contact me with specific questions, I'm always available to answer them. So as Sean said, yeah, I'm going to go through kind of just some general information in relation to data protection impact assessments. Going to have a look at the screening checklist, and then just a brief run through of the normal procedure for completing a DPIA. Now, what I will say from the outset is that every impact assessment is different. There is no one size fits all answer for every question. So it's almost better to keep it at a higher general level than even to try and give examples, because if you try and fit your stuff into an example, it doesn't always work. But as I say, if you have any questions, I'm happy to answer them. So, sorry, no. Of course, this isn't working.
So if you click the mouse, yeah, there.
Yeah, no, I was clicking, and I do apologize in advance, no, because my familiarity with Zoom isn't the best, so bear with me. So I'm gone too far there, actually. Okay, so what is a data protection impact assessment? I suppose first off, there's sort of common terms that are used in relation to data protection, stroke privacy, stroke the AI Act in relation to impact assessments. They're generally one and the same thing. They might have slightly different elements to them, but I would say that in terms of data protection, generally, data protection and privacy are interchangeable terms that are used. Privacy is a more global term, whereas data protection is probably seen more nationally and at a EU level. So that's why you might see privacy used around the place as well. They are interchangeable. So a data protection impact assessment, it's a tool really that the university uses to assess the risk to individuals where their information is being used in relation to a process, a project, a new system, or anything else that you know, for example, yourselves, if you're conducting research. It looks at the risks that might exist in relation to using that data. It looks at the measures that are intended to be put in place to mitigate those risks, reduce the risks, and then determine if the remaining risk is acceptable to the university. And I'm not going to go into the highs and lows of risk analysis because that's a whole different presentation to give. But generally speaking, what are the risks? What are we doing to, you know, to minimize those risks, and are they acceptable? And in most cases, in 99% of cases, we will be able to put in measures that reduce the risk to an acceptable level. If we can't, there is an option to consult with the DPC and get their advice on it. And if they determine that the risks aren't acceptable, as I say, in a really limited number of situations, then the process or the system being looked at may not proceed. So I suppose it does go to that level, but very, very rarely. It's particularly relevant, I suppose, when you're starting something new. So if you're implementing a new system, if you're starting a new research project that's looking into an area that hasn't been looked at before, or if you're using a new piece of technology. And I suppose it also needs to be looked at if you're making a substantial change to how you currently do something, or if you're going to be utilizing the same set of data for something else. So they're the various different reasons why you look at doing a DPIA. And the other thing that's important about it is that we have to comply with GDPR, and there's what's called the accountability principle. And carrying out a DPIA where it's necessary, and sometimes even when it's not, demonstrates to individuals that we take our compliance seriously and that we are making every effort to comply with data requirements. So When should a DPIA be conducted? Of course, it's data protection. So the first thing that you have to look, the very, very, very first question is, am I utilizing personal data? And if you are utilizing personal data, then you go to the next stage. If you're not using personal data at all, then you don't have to conduct a DPIA. It's as black and white at that level. And the next step then is that if you determine that you are using personal data, then you go to the criteria, which we'll get to further down, which are the selection criteria. And if you answer yes to one of those, then you need to carry out a DPIA. Technically, if you answer no to all of them, you don't, but you might feel sometimes that it's a little bit borderline and you're not 100% certain. Some situations, we still recommend, in the broader sense of the university, carrying out a DPIA, because it does answer questions. And again, it does demonstrate that we take our data protection obligations seriously and that we do put in the effort to make sure that we're compliant. Sean had a screen up earlier where he had the 10 criteria. The three big ones really are systematic and extensive evaluation of personal aspects relating to individuals, automated processing, profiling, processing on a large scale. And again, now, you know, how long is a piece of string? What's considered processing on a large scale? And systemic monitoring of a public accessible area. So CCTV is the big one there. So as you know, we have to have signs up. We have to let people know, even if you have a CCTV in your house, just so everybody is aware. You know, you can have a CCTV system in your house. You can have it looking at a particular area, and that's all fine. Mind yourself, your recording area. Because if you're recording outside your perimeter, then you're actually breaching data protection, even in your home. So maybe use a bit of advice there. Again, as Sean said earlier, a DPIA should be conducted at proposal stage. So at the very earliest part of the processing. And that's not just in relation to research, that's in relation to anything. There is a bit of a misconception and sometimes a bit of confusion when you're looking at purchasing technologies, for example, that it's the vendor you're assessing. So it tends to be late in the day. It's not. It's the use of personal data, regardless of the vendor, regardless of what you're going to be using to do it. You need to assess what risks are associated with the processing itself. So the method of processing isn't important. It's what you're processing. And for some projects, as I said, you might do it regardless of whether it's mandatory. And in other ones, it's evolving. So you might do it at stage one, and then you might find out halfway through your project that certain things change. So you might revisit it, or you might find that there was a new risk came into existence, and that you have to put that into your DPIA. So always bear that in mind, that you can revisit it. It's not just something that you do and then it's done and you close it away. You should come back to it. And then generally not required when there's not likely to be a high risk to the rights and freedoms of individuals. When the second one there is, it's difficult to give examples of it, but imagine government decided to introduce a particular process and it was going to be in a number of departments first, and then they decided later to roll it out to other departments. Those departments wouldn't necessarily have to carry out a DPIA because the pilot ones did. That's kind of what that means there. The next one, again, would be very, very unusual to relate to MTU. It's that where there's a legal basis in a member state. And then the last one is, again, very unlikely, the optional list, which we don't have an optional list. So this is basically just a diagrammatic version of what I've said there previously, is how to determine when and when you shouldn't carry out a DPIA. So it's, you know, it's fairly good view of it. So is it likely to result in high risk? No, no DPI needed. likely to resist? Yes. The exceptions there are those ones where a DPIA has been carried out for something similar in the past and is not required, or it's set down in law. If there is an exception, then you don't need a DPIA. If there is an exception, you should do one. Processing review by the controller. The residual high risks there down the right-hand corner, I think that's important. If there are residual high risks, that prior consultation there is in relation to the Data Protection Commission. So that's the option there. Okay, and I suppose the next thing then is who should be involved. Obviously, I have a role, and I'm there to assist, to answer any queries that people might have in relation to completion of the form, because obviously when it's something new, people have questions, they're not maybe certain how to answer particular questions. And I'm there to comment back on it, to look for additional feedback, to maybe make recommendations, and then to assess the risks and the mitigating measures that are going to be put in place. The most important people there actually to complete the DPIA are those involved. So those people that are actually want to introduce the process or the system, yourselves who are carrying out the research, you're the experts in the area. You're the best place to actually set down what is being collected, how it's going to be used, how it's going to be secured, how it's going to be stored. And then the advice, if you want to get external advice. So if it involves technologies, we might involve, say, IT and get their views on the how those systems should be implemented or what security systems we need and penetration testing and all those kind of things. So you may have external people as well. And if you do have sub-processors, often we would invite them to make an input because they would be expert in their particular area of the project or the system. Okay, so I suppose this is an important one, I think, because it's another step that you're being asked to put in place. It's an additional form that you have to complete, and you know you're there. You already have a certain number of forms to do. Another one into the mix maybe just seems a bit like overkill. But going to the benefits, the one that I mentioned earlier is demonstrating our compliance. It's very important for people to know that we are doing our best to make sure that we're compliant with GDPR, that we're focused on it, and that we, as I say, we put any measures and practices in place that we can. Improves how the university uses information. Again, if you know what the risks are in relation to the data you're collecting and using, then you can be more careful with it, and you can ensure that is better protected. Financial benefits, obviously, it's easier to sort something out at the beginning, and that's the case with any kind of a problem, whether it's data protection related or not. If you identify an issue at the outset, then you can put the measures in place rather than having to come back and subsequently put in systems or checks and balances that are required. And again, increases the awareness of privacy and data protection issues within an organization. And again, I think if you've carried out a DPIA, the stakeholders, the participants in your case, it demonstrates to them, again, that you have taken that step to identify the risks and put in place the necessary measures to secure it. So has anybody any questions to date, or will I carry on?
There's nothing in the chat at the moment anyway, Carmel, so I'd say...
Am I going? Okay, so...
No, you're going perfect. No, I'd say keep on now.
Perfect, I keep on trucking.
Yeah, all super. There's somebody's after saying in the chat there, so all good. Thank you very much.
Okay. So these are our responsibilities in relation to data protection impact assessments. Identify the need for a DPIA. As I said, the very first question is, are you processing data, our personal data? Describe the information flow. Identify privacy and related risk. Identify and evaluate privacy solutions. They're the mitigating practice. And again, this you'll see is the use of privacy as opposed to data protection. Record DPIA outcomes, integrate the DPIA outcomes into the project plan. So we're going to go down through this. As I say, I'm not going to spend a huge amount of time on it, because every single time you fill one out, it'll be slightly nuanced. So we'll start with the first one there again. So look, decide if a DPIA is required. Once you've established that you have personal data, that you're going to be collecting it or processing it or storing it, or accessing it. So, you know, some people think just because they don't keep a record of it or hold it, even if you're accessing personal data, that constitutes using personal data or processing it. And then we have the screening questions. So I suppose the first one there, and what I've done is there are kind of a bit more information on them and an example. So it might just give a better view of the criteria themselves. Evaluation or scoring of personal data, including profile and predicting. So the context of this, it's particularly important when personal data processing relates to an individual's performance, economic situation, health, personal preferences or interests, reliability or behavior, location or movements. And an example is building behavioral or marketing profiles of individuals based on their web activity. We're all very familiar with that, with the ads popping up and stuff like that, and how there has been a lot of move to kind of curtail all that kind of practice. But that's one example there. Automated decision making with legal or similar effects. Aim to automate decisions about individuals that produce legal effects or similarly significant effects upon the individual. So asking an individual to submit personal data that is then analyzed by a computer system, with the result that the individual's request to use a service is either accepted or refused. Now, the reality is that you could look at something there like an online loan application. And it's not that, you know, where you fill up a form and, you know, almost instantly. I mean, I give a personal example. I applied for a grant recently for something, and I got an immediate email back. So it obviously just analyzed what I had input into the questions and gave me an immediate response back. Now, it was in the positive, so I didn't have any questions with it. But in relation to the automated decision making, if that's an element of your project or of your process, that is still okay. It's not that it's not permitted, but the way to offset the risk and the issue there is that you would have an option that if somebody's not happy with the outcome, that they can get to speak to somebody and that they can actually have that personal rapport and discussion with somebody afterwards. So that's an example there. Systemic monitoring, again, that's a CCTV one, is the best example that you can give there. You could have possibly, if you went into if we monitored people's computer usage or logins, or that was done on a very large scale. Sensitive data, I think most people are familiar with what constitutes sensitive data, and you know the primary example, which is probably particularly relevant to yourselves, is if you're processing the health data of research participants in a research project. Data processed on a large scale. Again, as I said earlier, how long is a piece of string? So I think that processing data on a large scale there depends on your pool. So if we think of our pool of students at around, you know, even if you said 20,000, processing on a large scale there would be maybe 50% of them. I would think anything 50% up. So look at your pool, look at the number of people you're going to be processing data of, and you'll get to a figure there. It's most unusual that it will apply to us or apply to you. Matching or combining data sets. So again, there's an awful lot of talk in relation to anonymization and pseudonymization, but if you recall or maybe, you know, if I can remind you that the definition of personal information is where an individual is identified or identifiable. So that means that if you have somebody's car registration number and you have something else, and you can link the two together, then you can find out that this car actually belongs to this individual. So if you had their driving license number, or an insurance policy number actually is probably a good example. So previously, if you were applying for motor tax, you would input your insurance number, and your insurance number is linked to your information in your insurance agent rather than in anywhere else. So again, it's matching or bringing two sets of data together, which can lead to somebody being identified. And it's a greater risk because it's two separate pieces of data and is not necessarily seen as a great risk. Data concerning vulnerable people, again, this is kind of linked to using sensitive data, but it's just looking at your data subject pool as opposed to your personal data category pool. Again, vulnerable people, children are the major example there. Innovative use of applying technological or organizational solutions. New technology can often involve novel ways of collecting, using personal data that individuals may not reasonably expect. Fingerprint technology or facial recognition to access a building. We haven't introduced that, or we don't really use biometric to any great degree yet, and it's something that we would have to take a big look at and really make sure that the risks were minimized there. Processing, preventing data subjects from exercising a right or using a service or contract. So screening applicants before allowing them to use a web service. It's processing that takes place in a public area that passers-by cannot avoid effectively. Processing involves the transfer of personal data outside the European Union. So the example given there is actually in the USA, and this could really change. So we could possibly take out the USA at the moment because we do have an adequacy agreement with them. But how long that will last in relation to the USA is hard to know because somebody may challenge the current one again. And what I would say is that even with that adequacy agreement, we still are careful about outside the EU as opposed to inside the EU. Okay, so these are very high level. The DPIA itself has questions. It's been modified and redesigned a few times to try and make it a little bit easier. There's a box for every question now, whereas they all used to be lumped together. But I suppose the information flows. How will personal data be obtained? How will it be collected? Where's your data source? How will it be processed? And as I say, process there means everything from accessing it to using it to contact people, to carry out the whatever research you want, recording videos, how personal data will be stored. It's very important. We, particularly given everything that's happened, we're obviously going to be in a spotlight, and we need to make sure that all our personal data is very well secured. We should use every technology available to us, encryption, etc. And I would advise anybody really, if they're going to be collecting and storing personal data, just to maybe liaise with IT to get their input into how it should best be stored. To whom personal data will be disclosed. Again, we need to collect and store that information. We need to know who the personal information is going to be shared with. So if I can give an example there, maybe not non-research related, it might make more sense. So we have students that access particular services that are funded. We keep a record of those. That's an EU-funded initiative, and in order to make the claims and get the funding, we need to provide the EU with information, which often would involve the sharing of personal information. And if anybody looks at our privacy notices, there's a section in our privacy notices which set out, but not limited to, organizations that we do share data with. And these are important, I suppose. This information is important when you have to prepare the notice that you give to individuals, because you do set out all this information. You tell them as much as you can so that there are no surprises from them down the line. And again, that we're compliant with our requirements. Consultation should begin during this step. So again, if that's probably just a general statement there. Identify privacy and related risks. So this is just the process itself. But again, the purpose of a DPIA is to look at what data you're collecting, look at how you're going to be using it, who's going to be accessing it, how long you're going to store it, how you're going to store it, how you're going to dispose of it, and determine what are the risks that are associated with that. And, you know, the risks can be, we'll take that last example of sharing information outside the EU. So the risk is that you're using somebody who has their cloud server in outside of the EU. So I mean, yes, some, for example, Amazon Web Services. Amazon Web Services have cloud servers in the EU, outside the EU, and in some cases you can select that you want them within the EU. But say you're dealing with somebody whose cloud server is outside the EU. And that's a risk, because the risk is that the data is breached, and it's breached by a company who stores their data in a country that doesn't have the same level of protection that is required under GDPR. So that's the kind of risk that you're identifying there. In relation to storage, you might say that there's a risk that there'll be unauthorized access. So these are all your risks. There's nobody saying that they're your residual risks, but they're risks that are in existence. So you identify any potential risk that's associated with the data that you're collecting. Sorry, if I go back up just to, again, this is about risk assessment, and I'm happy to sit down and take people through these, because, you know, this is a subjective thing. If you give people two different people the same risk to assess, they might come up with a different answer. It's all about your perception. So I'm happy to give people advice there. This is just the standard of recording a risk. So unique identifier, a description of the risk. So so not the impact of the risk, but the actual risk. Again, I'll go through it with people when the time comes, and the best way of learning that is actually by doing assessment of the impact of the risk. It's severe, major, moderate, minor, and significant. And these are the gross, what's called gross risks. So before you have any measures in place. So what would happen if you had no controls in place and this happened? And then assessment of the likelihood. So is it very likely or very unlikely? Identify and evaluate privacy solutions. These are mitigating measures, and they're called controls. So again, you're dealing with a third-party service provider who has cloud servers in various different locations. Okay, how do you reduce the risk of it being outside of the EU? You ask them specifically in your agreements with them to have the servers located in the EU. So what might have been a high risk starting off has this control in place, and then that reduces the what we call the residual risk to a medium or a low level. Okay, and you do that for each of the risks that you identify. If I go with the other one where you have unauthorized access, so what controls do you have in place? If you think of the usual suspects, we have access to the servers limited to those people who need to access them. We use multi-factor authentication, and we check them for security periodically. And then, as I say, record the expected result of implementation of the control. Risk elimination, great. That's the ideal. Very rarely happens. Reduce the risk to an acceptable level. That's the norm, really. It's very difficult to reduce a risk to zero, because the best controls are not infallible. There's no absolutes, is probably the best way of putting it. require acceptance as there is no reasonable control to eliminate or reduce it. Yeah, sometimes we have no choice. And sometimes what happens there is that sometimes you have to just accept a risk because you have to implement what you're implementing. And how we do that is we don't take that decision ourselves. We would normally refer that up the line. In general terms, in the wider university, what we do is we refer to university executive. So you set out your risks. You say, this is a very high risk. None of the controls that can be implemented are going to reduce it to an acceptable level. And it's up to them then to make a decision. And sometimes the need for the solution outweighs the risk. Probably the best way of putting it. The proposed controls should then be approved. So they should be agreed, approved, signed off, and then we come back. And the next step then is just to make sure that we record the outcomes. So whatever has been decided, I might make comments in relation to it. I might say that I deem that the risk measures are sufficient. I might make a suggestion that the measures or the controls that have been put in place should be reviewed for effectiveness after a month, or after 3 months, and then it should be signed off and accepted. I would suggest in your case it's probably by the research committee, along with the proposal. But we haven't actually trashed that out as yet. And integrate the DPIA outcomes. Again, that's if I've made any recommendations back, and we need to make sure that the controls that have been identified to mitigate the risks are put in place. And that's it. And that's me. If anybody needs to contact me directly. So
thanks very much, Carmel. That's brilliant. So useful and quite clear, just the experience that you have with the area, with the topic when you're presenting there, and how clear, so clearly explained as well. So thanks very much. There's a couple of questions in the chat here, so if you don't mind, I can call them out to you and that you go from there. Okay, so one straightforward enough. One is, what is a unique identifier?
In relation to a risk, anything. Basically, it's like if you could start it at and your research code. So if you have a particular reference on your research project or your research submission, you could use that and call it R01, R02, R03. So it's just that it's just a standard thing, really. It's nothing special.
That's perfect. Super. Got a thumbs up in response there to that one. Another question then is, if storing contact names, like emails, company names, and so on, is this classified as personal data rather than personal sensitive data? And in this case, is a DPA not required?
No, DPIA is not necessarily just about what categories of data you hold. It's about how you're going to be processing it. So the criteria there are if you're using that data in a novel way, if that was one of the ones that was there, if you're processing it on a large scale. So you could just be having names and addresses and contact details, but you could be using it on a very large scale, in which case you would have to conduct a DPIA.
Okay, so just on that one then, so just say as part of a research study, we were collecting some names and email addresses, but it was on a small scale. We just say 30 names and email addresses, and we're going to have that stored as part of the research study. Is a DPIA needed in that case then?
Unlikely, because you're most likely to click no to all of the criteria. Yeah. Right. So I think the question, maybe this is the question that's asked, right? All of that information is considered personal data. So you've got the first part is, might I need a DPIA? And then the criteria need to be filled out to determine if you actually need a DPIA, if it's mandatory.
Very good. And just say then on that, because there's something I made note of here, just say we have data collected, but it's completely anonymous, and we're going to share it with, we'll say, somebody outside of Europe. So I'm just thinking of, the 10th point that you had there on your screen. What's that? What's the status with that?
If it's anonymized, then it doesn't contain personal data, but you need to be absolutely certain that it's anonymized. So anonymized means that you cannot link it, that there's no keys back that can
Mhm.
or de-anonymize it. So that's the important thing there. It's maybe this is where this unique identifier might come in. You can't have kind of have a secondary key in there. So
Yeah.
you like, if I say it this way, so if Carmel Hayes is written in a spreadsheet, right? You can't change Carmel Hayes. You can change Carmel Hayes to 1. Just change it to 1. Carmel Hayes' name is gone. That's fine. But you can't change it to 1 and have somewhere else 1 equals Carmel Hayes, because that's linking. That's pseudonymized, not anonymized. You cannot link it back.
Perfect. So, and that's terminology that we use in the hate track as well, around kind of pseudonymization or potentially identifiable. So if we have data, or in a research study, if somebody has data that's going to be either pseudonymized or they call it potentially identifiable, and they're going to be transferring it across borders as an outside Europe, then that would require a DPIA.
I think so yeah,
It
because
would
one of the
definitely
risks,
require a conversation anyway on it.
yes, absolutely. Yeah.
Yeah, perfect. No, because we do, just sure, obviously we do collaborate as a university and
Yeah.
we do collaborate with colleagues outside of Europe. So it's just kind of to have that clear as well. And so, okay, another question that came in there. If the unique identifier if the unique identifiers remain in the EU, but the data leaves the EU, is that okay? That's a good question as well. So do you know if the key stays in, we'll say here locally?
If the key stays low, okay. So I think the question there, I think the issue, I think we're actually gone too far. Okay. Because the DPIA is done at the outset, at the proposal stage. Sharing of the data is an element of your research project, but that's not the processing. The DPIA is done because of the data you're collecting and what you're going to be using it for. Do you know what I mean? Okay, if I go back a step, I think I understand what people are saying. If it's no to all the other criteria except that you'll be sharing data outside the EU, I think regardless of whether your intention is to anonymize it or pseudonymize it or whatever, you should complete the DPIA, because it's good practice there to have set out what it is you're doing, and to be clear at the bottom when you've done your risks is this is how we are going to minimize the risk of sharing data outside the EU. It's going to be anonymized. But I think it is important in those cases to fill it out.
Perfect. Thanks very much, Carmel. Another question, I'll take this one, but then I think there's going to be a follow-on, which I could maybe put in. So the question there is, does the DPIA need to be submitted and approved prior to submitting a full ethics application to the HREC? And the answer to that is yes, that's part of the policy. That's if a DPIA is required. If a DPIA is not required, what the HREC require then is the screening checklist with all the no's in it. And that's it. So then my follow-on question there to that then is, just say I'm the researcher, I require a DPIA. I'm going to submit it to you. I'm going to complete it. I'm going to send it to you to get your obviously your take then on it. How long does that take? Rough.
Okay, so it's difficult for me to give us an actual answer for that at the moment, because I have no idea of the volume that are likely to come in, the frequency, the urgency. I would like 4 weeks. I think 4 weeks, I would absolutely do my best to complete them all in 4 weeks. I do appreciate that this is new, and that some people maybe rushing now to try and kind of go back to the start almost and do it. So again, I will do them absolutely as quick as I can, but I think 4 weeks is probably a reasonable time. But I'm happy to look at what happens over the next 2 to 3 months, and if that can be shortened, or it needs to be lengthened, or we need to do something else, throw more resources at it, then absolutely we can come back and revisit it. But I think maybe one of the things is that even the submitting of the determining if a DPI is required or not is sometimes just a conversation that can be done relatively quickly.
Brilliant. Carmel, and to me, 4 weeks is a great turnaround. So that sounds very good. Thanks very much. I don't see any other questions appearing there in the chat. So maybe just one other question then, maybe just for myself. So if it can, so the screening checklist, that's up on our research ethics, the human research ethics webpage. Sinead popped that into the chat there early on. If somebody needed to actually complete the DPIA, then do they reach out to you then, Carmel, to get the DPIA?
No. Well, they can, that's no problem, Sean, but I'm actually, I've asked IT to upload it. There's a data protection section in WorkVivo, where the policies, it's under policies, it's under governance and corporate affairs or something like that, subfolder data protection. I'm going to put it in there, but what I'll do is I'll send on the link and you can put the link in wherever you want. As they say, I just want to have one document, one source document, because at least then if it's updated, you always have the most current one, because these things are by nature, they develop over time. And I suppose the other thing is that as we progress, and obviously, unfortunately, the event of 2023 kind of took its toll and set us back a little bit in our development, but there are things and advancements that we can make as well in relation to how these things are submitted. I have some very good digital templates that we can kind of start to bring in. I don't want to get anybody's hopes up, but hopefully in the latter half of this year we'll get around to kind of making a move and developing our own data protection submission site as well.
Super. That sounds great, Carmel. And with that, with the form, like we can put it up on the webpage and signpost people then to that. That's actually great. Just there's compliments there just in the chat of the presentation, so helpful. And I definitely find just having this and just having the opportunity to ask those couple of questions is so helpful. And like that, this session has been recorded. I know everyone here is here, but it's something that you can kind of make note, link into later on. So we're going to have it on our YouTube channel and on SWORD, our institutional repository. And then after that, I suppose it's just simply loads of thanks and praise coming in there, Carmel. So thank you very much for that, because I know there's, for these sessions, there's always time involved to prepare for it and everything like that. And it's just, it's very evident the preparation you put in today. So thank you very much for all the work. And thanks to Sinead McDonald in the background there as well, that helped out with kind of organizing the logistics for this event as well. So I think we can leave it there. Thank you very much, everyone.
Great stuff. Thanks, everyone.
All the best. Bye-bye.